Hey everyone, King here, back for another video. I'm going to do a reaction to this news article that was published on October 2nd about a lady losing her family's heir property. So I'm going to do this, I'm going to break it down into two parts. The first part I'm going to cover the article, and then the second part I want to get into the legal action that was taken by her and an attorney and to her trying to acquire the property. So without further ado, let's get into the video. Thanks for watching.
South Carolina family that lost Heir's property over $112 tax bill loses again in court. Somerville, the property Wendy Reed's great-grandmother inherited in 1957 near downtown Somerville, was sold in 2012 to pay a $112 delinquent property tax bill, and after years of fighting Dorchester County in court over it, Reed has conceded defeat. A lawsuit that framed the sale as a civil rights issue ended this summer when the South Carolina Court of Appeals upheld an earlier ruling in the county's favor. Former state lawmaker Thomas Limehouse, who bought Reed's eighth of an acre family property for $2,000 at a delinquent tax auction, also a defendant. Reed says she hopes to buy the property back from Limehouse, who said he's been negotiating with the family. Reed's lawyer Nancy Bloodgood had argued Reed should have been able to buy back the property before the county transferred it to Limehouse in 2014, but that she faced discrimination as a black heirs property owner. Bloodgood said Dorchester County refused to let Reed reclaim the tax delinquent property because her name wasn't on the deed. Heirs properties are those that have been handed down through families without benefit of written wills or probate court, leaving them with tangled titles. Reed's case illustrates how delinquent tax sales are a particular challenge facing heirs property owners. People who lose a property through a delinquent tax sale have a year to reclaim it by buying back taxes, fees, and interest. But those with heirs property face the challenge of proving it was their property to reclaim. I never understood the problem with living on heirs property, Reed said, who raised a son and daughter in her manufactured home on West Richardson Avenue. She's continuing living there with her husband and 3 grandchildren while the court case played out. I never knew it was so easy to lose property like that, Reed said. As one heir of the deceased former owners of the land, Reed owned 1/75 of the property, but none of that was legally recorded. It's not an uncommon situation in South Carolina, particularly in black communities. Heirs property has been cited by federal officials as a leading cause of involuntary losses of black-owned land during the 20th century. Reed had paid the taxes on the property for years, but when it went to the delinquent tax sale and she sought to reclaim it, Dorchester County wanted her to prove she was the owner. At that point, it was too late to probate the estate. Turning up the ownership stakes of the multiple heirs legally would have been costly, and such procedures often takes years. It didn't seem to matter as long as I was paying, Reed said. They were happy to take my money. Josh Walden, Chief of Operations at the Center for Property Preservation, said Reed has sought their help and was told that she needed to redeem the property, reclaim it for the tax sale process, before the nonprofit could help her clear up the deed. Walden said he's not aware of any other South Carolina county that has such a strict interpretation of what constitutes an owner. It's an interpretation that can be devastating to a family, he said. At least every county I've come across, this hasn't been an issue except for Dorchester. Reed lived on the property and paid the annual tax bill for years until she didn't in 2011. The property then went to an annual delinquent tax auction in 2013. However, having paid the taxes didn't legally make her a defaulting taxpayer who could redeem the property, and she could not prove she was a grantee from the owner, which also would have allowed her to reclaim the land under state law. I went to the big courthouse in St. George and they told me I had to probate the land, said Reed. I didn't know what probate was. Walden said most counties would just accept payment and the property will return to its previous status as an heirs property with taxes up to date. Treating heirs property owners differently in delinquent tax sales is a practice Bloodgood claim has caused the loss of a significant amount of African American owned property in rural Dorchester County and is motivated by a discriminatory intent. Courts did see that way. In a 2019 decision that was upheld on appeal in the summer of 2022, Circuit Judge Edgar Dixon put the blame for the loss of Reed's family property on Reed's shoulders, writing, "It was plaintiffs that failed to pay taxes, failed to respond to the certified notices, failed to probate her father's estate, failed to have the probate court make a determination of heirs, and failed to respond with any other information necessary to determine her eligibility to redeem." Dorchester County, through a spokesperson, refused requests for interviews with officials involved in delinquent tax sales and declined to comment on the 8-year court case beyond stating the county has and continues to follow the law regarding delinquent tax sales and the sale of property. The county's defense was handed by State's Insurance Reserve Fund. After Reed's property went to sell, Dorchester County said it certified notices to a dozen parties with an interest in the property, including Reed's great-grandmother, who died in 1984, and her late father. None of them responded according to the county, and Reed was not among those the county listed as having been sent notices. I know Dorchester County did what they should have done legally and morally, said Limehouse, who was a lawyer before he was sent to jail in 1991 after his guilty plea in the Operation Lost Trust South Carolina State House bribery scandal, and his law license was suspended. Takeaway, he said, should be that this is all the more reason why people need to probate property. Limehouse had also purchased at a tax sale Heir's property, partly owned by Reed's sister, and later sold it back to her. Everything is amicable, and no one seems bitter, he said. Limehouse said he's currently talking with Reed and her husband about renting the property they live on, which now he owns, and potentially buying it back for them.
So that's everything in that article where Miss Reed had, unfortunately lost her property due to her not paying a delinquent tax bill. Again, it's unfortunate. As I said before in my other videos, that there's laws out there to help preserve and protect property, and there's laws out there for individuals such as Mr. Limehouse to acquire land at a tax sale, or even by buying up shares of Heir's property from individuals that allegedly own the property, right? And going to the court, petition to the court for the Heir property to be partitioned and sold, so that individual who has a greater share, or even like say 20% of ownership of the property, can force it to be partitioned and sold, so that individual can buy the other share or other parts of the land, remaining parts of the land, to use as they see fit. Yeah, it's definitely unfortunate, but if you see my other video, my reaction video, where I talk about the article of the 4 brothers that tried to acquire their land that was taken from them because somebody drafted up a quitclaim deed and put the property in their name without even proving that they were heirs to property, and then passed on that quitclaim deed, the title of that property, down to her son, and those 4 brothers spent $27,000 and several lawyers later, and still have not got it resolved, have not acquired the land back. Now, in my experience in dealing with heirs property, I use the law on the books to preserve and protect it, and individuals had a right to come forward and state their claim. They get their name on paper. They get their names added to the title to the property. Again, if you see my other videos where I talk about it, clearing the title to the property based on law. It's no different than going to probate. The original owners of property died without a living will, passing on their ownership to their children, or to a spouse, or to whoever. So they died intestate. So South Carolina laws is, when that happens, the property now becomes heir property. So everybody that is a living heir of said individual has equal interest in the property, unless it's stated in the order or any kind of legal document where this lady had 1/75 of interest in the 1/8 of an acre of property, which is not a lot. But she didn't know what probate was, and she didn't know how to get her property cleared up, the title cleared up, to where she can reclaim it. But they were taking her money as long as she was paying the taxes on it. It was fine. But the minute that it was sold, there's the issue. you have to clear title. You have to go to probate court to ask the court to determine who the living heirs or descendants of to the state. You know, Papa Sim, Sammy Cox, who is one of the children of Toby Cox. He said it in the article, and I can put it somewhere up in here, highlighting what he said. He said there's nothing to take but the tax. He even said that in the article that the land is tied up in legal considerations that it can't be sold. Well, her property was sold, and it was tied up. But all right, money had a muddy title, had a tangled title. It was not cleared, but it was sold because they failed to pay the tax. She failed to pay the tax, $112. But yet, members of my family are saying that I'm trying to sell this property because I brought it before the court. But yet, other individuals who sued my family took them to court, other transgressions, saying that they conspired to steal this property, they conspired to steal this. But it's okay for individuals to lay claims to being living heirs, descendants of individuals that allegedly own the property, to include my second great grandfather, Washington James, but come to find out it's not true. But yet they could do that. But me and my family are wrong for filing a lawsuit to acquire the title. They're trying to clip the title. So that doesn't happen to us. What happened to Ms. Reed doesn't happen to us. Not just me, and not just my family, but the living heirs, descendants of Washington James and Toby Cox and everybody else. Again, everybody had the opportunity to come forward, but they didn't want to. Matter of fact, they started it. And there's documentation to prove it. That prior to 2011, the individuals started a process to clear a title, but yet people were not cooperating. Why is that? What is so wrong? What is so bad for somebody coming forward and says, yes, I'm an heir to property, and here's how to add their name to the title to the property, to clear up title. They remove the title, remove those names of individuals who originally owned it, such as Washington James, Toby Cox, and other men and women, their brothers and sisters, their spouses, whoever. Say now, put the title, put the land, the title to the land, and the living heirs, descendants of them, such as the grandchildren, the living grandchildren of Washington James, or the living great grandchildren of Toby Cox. Because those individuals are dead. Members of my family, my great aunts and uncles, who are the siblings, living siblings of my grandfather. Or, they have rights to the property. Why isn't it entitled in their name? Or how about on my grandmother's side? Because my grandmother's deceased now. And the only ones remaining are the great-great-grandchildren of Toby Cox, who are the grandchildren of Sim Cox. My elderly cousins, my first cousins, or actually I'm their second cousin, but the first cousin to my mother. How come their names aren't on the title? They have rights to this property. But yet individuals that claim to be living heirs, descendants of Washington James with no proof took members of my family to court just to stop them for claiming the title to the property. Accuse them of spending money, accuse them of all this stuff, but yet when I brought them before the court, I'm wrong. I'm wrong. Me and my family are wrong. We Jameses are wrong. We're wrong for doing what we did. Are we? Are we wrong for trying to preserve and protect the property from people that try to get it? Because Papa Sim said it. And it might be oral history, it might be hearsay, but members of my family told me that Papa Sim said it. That when he closed his eyes for the last time upon his death, people are going to come and try to get this property. And sure enough, people have tried it. And they're still trying it. And I'm spending my time, energy, money fighting for it to preserve and protect it. But yeah, I'm trying to sell it. I got cousins that go out there spreading false information and lies about me that I'm trying to sell this property. Calling my cousins, spreading lies, calling other family members, trying to get the ear of anybody else to be on their side to put them against me. Anyway, so in the video here, but I will make it a part 2 of this video discussing the complaint against Dorchester County, as well as Mr. Limehouse, whose name was also a defendant in the case. So please stay tuned for that video, and I'll see you in that video. All right, take care. Peace.